Your Honors, case number IT 9514/2A, the prosecutor versus Dario Kordić and Mario Čerkez.
Thank you. May I have the appearances, please? First, the prosecution.
Counsel appearing for the prosecution, Your Honors, is Norman Farrell, and Ms. Helen Brady, Ms. Marish Lekind, and Ms. Michelle Jarvis. Also appearing with us in court are our case manager, Lourdes Galizia, and the senior trial attorneys from the trial, Mr. Jeffrey Nice and Mr. Ken Scott. Thank you, Your Honor.
Thank you. And for the defense, please. The defense for Mr. Kordić first.
Thank you, Your Honor. Good afternoon. The defense of Mr. Kordić in the person of my colleagues from the United States, Stephen Sayers, Anthony Smith, and my name is Mitko Naumovski, a lawyer from Zagreb. Thank you.
Good afternoon, Your Honors. For Čerkez defense, Mr. Goran Mikulicic, my co-counsel, and myself, Božidar Kovačić, attorney from Croatia. Thank you, Your Honor.
Thank you. I note that your client in writing has waived his right to be present when the summary of the judgment will be read out. Correct?
Yes, Your Honor, he waived his right.
Thank you. May I finally ask Mr. Kordić, can you follow the proceedings in language you understand?
Thank you for asking, Your Honor. Yes, good afternoon. I can follow the proceedings in language I understand.
Thank you. You may be seated again. Before reading out the summary of the judgment, I should like first to thank everybody having assisted in the preparation, translation, editing, and printing of this judgment. The appeals chamber of this international tribunal has come together today to deliver its judgment on appeal in the case Prosecutor versus Dario Kordić and Mario Čerkez. The following is a summary of the appeals chamber's judgment, which is based on the final deliberations of 2 December 2004. It will be made available in English, French, and BCS at the end of the session, in particular to the accused in language he understands. Copies of the judgment will be made available to the parties towards the end of the session. It has to be emphasized that the only authoritative account of the appeal's conclusion is to be found in the English version of the written judgment. The events giving rise to this appeal took place during the conflict between the Croatian Defense Council, the HVO, and the Bosnian Muslim Army in central Bosnia from 1992 until 1993, in particular in the Lašva Valley region. This region, situated at the heart of central Bosnia, consists of the municipalities of Vitez, Novi, Travnik, and Busovača. The municipality of Kiseljak lies to the south of Lašva Valley. The military significance of the area lay in its position in the middle of Bosnia and Herzegovina, and the fact that it contained a number of armament factories. It is a mountainous area with important roads running along the valleys, going from Herzegovina to eastern Bosnia and from Sarajevo to the north. Novi, Travnik, and Kiseljak, about 30 kilometers apart and connected by a road, mark the area at the center of the events in this case. The village of ICTY, in which the most serious massacre in this case was undisputedly committed in mid-April 1993, is situated along this road. Let me now turn to the accused. Dario Kordić was born on 14 December 1960 in Busovača in Bosnia and Herzegovina. He is married and has 3 children. He is a former journalist, and he was gainfully employed at the Vatrostalna company in Busovača from 1985 onwards. In 1991, Kordić became the president of the Croatian Democratic Union of Bosnia and Herzegovina in the Municipality of Busovača. In the same year, he became the vice president of the Presidency of the Croatian Community of Herceg-Bosna after its foundation on 18 November 1991. When the Croatian Community of Herceg-Bosna turned itself into the Croatian Republic of Herceg-Bosna in August 1993, Kordić continued to serve as vice president. Mario Kordić was born on 27 March. Mario Čerkez, was born on 27 March 1959 in Vitez in Bosnia and Herzegovina. He is married and also has 3 children. Before the outbreak of the armed conflict in the Lašva Valley, he was employed in the Slobodan Princip Seljo factory near Vitez. Čerkez was one of the founders of the HVO in Vitez, his first duty being assistant commander of the Vitez Staff, followed by commander of the Vitez Brigade. When the Vitez and Novi Travnik brigades were united, Čerkez became assistant commander of that brigade. Finally, in March 1993, Čerkez became the commander of the Viteška Brigade. The trial chamber convicted Kordić for planning, instigating and ordering, including persecutions, unlawful attacks on civilians and civilian objects, murder, inhumane acts, imprisonment, wanton destruction not justified by military necessity, plunder, and destruction or willful damage to institutions dedicated to religion or education. These crimes were committed in the municipalities of Travnik, Vitez, Busovača, and Kiseljat. The trial chamber found that Kordić played an instrumental part in ordering the attack on Amici in April 1993, an attack in which more than 100 Bosnian Muslim civilians were massacred. The trial chamber sentenced Kordić to 25 years of imprisonment. For crimes committed in Vitez, Dari Vitez, and Večeriška, Čerkez was convicted for committing persecutions and pursuant to both Articles 7.1 and 7.3 of the statute, for unlawful attacks on civilians and civilian objects, murder, inhumane acts, imprisonment, taking civilians as hostages, wanton destruction not justified by military necessity, plunder, and destruction or willful damage to institutions dedicated to religion or education. For these crimes, the trial chamber imposed a sentence of 15 years of imprisonment. The trial chamber acquitted Čerkez, however, of the charges in respect to the crimes allegedly committed by him in Amici. The appeals of Kordić and Čerkez are directed against all convictions. Kordić mainly submits that he was denied equality of arms and did not receive a fair trial. That the trial chamber erred in relying on uncorroborated hearsay evidence, that the trial chamber erred in finding that the Muslim-Croat conflict in central Bosnia was a unilateral Bosnian-Croat campaign of persecution, that he did not have responsibility for the events in Ahmici and elsewhere, and that no armed conflict existed prior to mid-April 1993, and finally, that the sentence was excessive. Čerkez mainly submits that no international armed conflict existed at the relevant time, that the trial chamber erroneously convicted him on the basis of Article 7.3 of the statute, that he did not receive a fair trial, that the trial chamber erred in the application of material law as a result of erroneous factual findings, and also he claims that the sentence was excessive. Finally, the prosecution appeals Čerkez's acquittal for crimes in ICTY and the sentences of both Kordić and Čerkez as being too lenient. During the appellate proceedings, various grounds of appeal were withdrawn, not the least due to the further developed jurisprudence of the International Tribunal since February 2001. In relation to some of the locations mentioned in the charges, the prosecution has conceded that the trial judgment does not contain the necessary factual findings. Let me pause for a moment for the following more general remarks. The fact is that this international tribunal has never had and will never have the opportunity to hear cases against all the persons allegedly being among the most responsible for the events in Lašva Valley in one procedure. Chambers of this international tribunal can only hear a case regarding a person against whom an indictment has been filed and confirmed and who is present in The Hague. The fact that, seen from an objective point of view, a case against an alleged serious offender is and will not be heard before this international tribunal may be due to several reasons, among them primarily that the prosecution had not enough evidence and or that there was insufficient cooperation between the international tribunal and the state, either in the past or still today. As a result, each chamber can only carefully analyze the question of individual criminal responsibility for the crimes committed in Lašva Valley in relation to each of the accused brought before it. It also has to be emphasized that each bench of the International Tribunal decides a case solely on the evidence before it. This evidence, and consequently the disposition, may vary from case to case, as it is mainly the parties who bring evidence in this primarily adversarial legal system. The appeals chamber, based on the evidence before it, meticulously determines, as a first step, whether a crime was established or not. Only then does it decide, again based on the evidence before it, whether or not an accused can be held individually criminally responsible for these crimes. With a view to the victims and their relatives, it has to be further emphasized that a decision of acquittal does not necessarily mean that a crime did not occur. It simply means that on the basis of the evidence, the accused cannot be held individually responsible for these crimes. Let me now return to the summary of the judgment and briefly repeat the law governing appellate proceedings. As regards errors of fact, pursuant to the jurisprudence of the International Tribunal, the task of hearing, assessing, and weighing the evidence presented at a trial is left primarily to the trial chamber. Thus, the appeals chamber must give a margin of deference to a finding of fact reached by a trial chamber. Only where the evidence relied on by the trial chamber could not have been accepted by any reasonable tribunal of fact, or where the evaluation of the evidence is wholly erroneous, will the appeal chamber intervene. When considering alleged factual errors raised by the defense, the appeal chamber will only intervene if no reasonable trial of fact could have reached a conclusion of guilt beyond reasonable doubt. When considering alleged factual errors raised by the prosecution, the appeal chamber will determine whether no reasonable trial of fact could have come to the conclusion of acquittal. Where a party contends that a trial chamber has made an error of law, the appeal chamber is empowered only to reverse or to revise a trial chamber's decision when there is an error of law invalidating the decision. I will now briefly turn to the law applicable in relation to the modes of responsibility of the accused. The trial chamber convicted Kordić of planning, instigating and ordering crimes pursuant to Article 7.1 of the statute. The mens rea for these modes of responsibility is established if the perpetrator acted with direct intent in relation to his own planning, instigating or ordering. A lower form of intent is established when a person who orders an act or omission with the awareness of the substantial likelihood that a crime will be committed in the execution of that order has the requisite mens rea for establishing responsibility under Article 7.1 of the statute pursuant to ordering. Ordering with such awareness has to be regarded as accepting the crime. The appeal chamber finds that this correspondingly applies in relation to the modes of responsibility of planning and instigating. In this context, I want to mention that the appeal chamber made findings on several other legal issues in the judgment, such as the question of a result requirement in the crime of unlawful attack on civilians or civilian objects, and the question of cumulative convictions. These legal issues, however, will not be further discussed in this summary. I will now address Kordić, first ground of appeal, and Čerkez, third ground of appeal, namely the alleged denial of the right to a fair trial under Article 21 of the statute. Kordić admits that the prosecution's frequent and substantive changes to its stated case against the accused were unfair, in that the prosecution failed to inform them promptly and in detail of the nature of the charges against them as required by Article 21 of the statute. As such, the prosecution allegedly confronted them with a, I quote, moving target. The appeal chamber finds that counts 1 and 2, persecutions for Kordić and Čerkez respectively, are too broad to be acceptable as to the geographic and temporal scope of the charges. One could, on their own, materially impair the accused's ability to defend themselves. However, the appeal chamber considers that counts 1 and 2 have to be read as umbrella counts encompassing counts 3 to 44, which further inform the accused in greater detail of the charges against them. With these specifications, the appeal chamber is satisfied that the accused were informed of the charges against them and were able, as they did, to defend themselves before the trial chamber against the charges contained in the umbrella counts. In this context, the appeal chamber notes that the expulsion and forcible removal of Bosnian Muslim civilians is mentioned in several paragraphs of the trial judgment. however, not on the part or responsibility of the accused. The appeal chamber finds that the reason for this is that the indictment did not sufficiently inform the accused that they had to defend themselves against the charge of expulsion and or forcible transfer. This vagueness of the indictment had not been cured in the trial proceedings. The accused argued that the prosecution violated its Rule 68 disclosure obligations during pre-trial, the trial, and the post-trial phase in various ways, and in relation to a variety of evidence. The appeal chamber notes that the prosecution has accounted for the presentation of the evidence in this trial in extenso, and is satisfied that it fulfilled its obligation to assist the trial chamber in good faith in view of the complex nature of the case and of the difficulties encountered in accessing large amounts of evidence not immediately accessible for the prosecution. Kordić and Čerkez failed to establish that the trial chamber erred in permitting any such alleged Rule 68 violation. The arguments are finally dismissed. Both Kordić and Čerkez submit that the trial chamber erroneously held that an international armed conflict existed during the indictment period and consequently found them guilty of grave breaches of the Geneva Conventions of 1949 pursuant to Article 2 of the statute. In addition, Kordić claims that no armed conflict existed before 15 April 1993, thus barring a conviction under Articles 3 and 5 of the statute. Contrary to the submissions of Kordić and Čerkez, the appeal chamber finds that the trial chamber did not err in relying on the overall control test, according to which an armed conflict becomes international when a foreign state exercises overall control over the military forces of one of the belligerents. In addition, the trial chamber did not err by taking into account the situation in other areas within Bosnia and Herzegovina linked to the armed conflict in central Bosnia when examining the international character of the armed conflict. Once an armed conflict has become international, the Geneva Conventions apply throughout the respective territories of the warring parties. The appeal chamber is satisfied that on the basis of the evidence before it, a reasonable trial of fact could have found that Croatia exercised overall control over the HVO at the relevant time. Likewise, the trial chamber reasonably based its finding on reliable evidence that Croatia provided leadership in the planning, coordination and organization of the HVO, and there was an international armed conflict between Croatia and Bosnia and Herzegovina. I will now turn to an examination of the crimes for which Kordić and Čerkez had been convicted by the trial chamber. The appeal chamber considers, however, that the trial chamber in most cases did not make specific and explicit factual findings with regard to each element of the crimes, but expressly concluded that the crimes were established. The appeal chamber considers that by explicitly finding that the crimes were established, the trial chamber implicitly found all the relevant factual findings required to cover the elements of the crimes. The appeal chamber considers that such an approach falls short of what is required by the statute of the International Tribunal. However, this does not automatically lead to a dismissal of the charges. The appeal chamber agrees with the submissions of the prosecution that, in this particular circumstance, the issue before it is to establish whether the trial chamber's findings that the crimes were established are sustained on the record. Therefore, the appeal chamber had to consider the crimes location by location and element by element, determining whether the trial chamber's finding that that particular element was factually established is a finding that a reasonable trial of fact could have made. I will not discuss each of these crimes in great detail now. For the purposes of this summary, it suffices to state that a number of crimes have not been established and that the corresponding findings of the trial chamber had to be reversed. The disposition, however, will explicitly identify location by location each crime for which the accused finally are convicted. Before I now turn to the grounds of appeal dealing with the individual criminal responsibility of Kordić and Čerkez, I would like to note that the appeal chamber particularly examined the trial chamber's analysis of those orders and plans that were lawful and others that included the commission of crimes. In this context, it was important to consider the participation of Kordić and Čerkez at the various meetings with different groups of people that were held on 15 April 1993 in the Hotel Vitez, as this leads to a different knowledge and awareness on the part of the accused of the crime committed thereafter. Kordić argues in his third ground of appeal that the trial chamber erred in finding that the Bosnian Croats were engaged in a campaign of persecution in central Bosnia and in finding him guilty on this charge. In particular, in relation to the massacre in Ahmići, the appeal chamber considered that a reasonable trial of fact could have concluded that there was a meeting of the Bosnian Croat political leadership on 15 April 1993 at the Hotel Vitez and that Kordić was present at this meeting. It was also reasonable to conclude that at this meeting a decision to launch an attack against the Muslims was made. Based on the entirety of direct and circumstantial evidence, a reasonable trial of fact could have concluded that for Kordić, this attack on Ahmići and other Lašva Valley villages was aimed at ethnically cleansing the area for strategic reasons. The appeal chamber also holds that it was reasonable to find that Kordić, as the responsible regional politician, planned and instigated the crimes which occurred in Ahmići on 16 April 1993 and its associated hamlets Čančići, Pirići, Nadioci. In light of the appeals chamber's finding that it was indeed reasonable to conclude that an order was given to kill all Muslim men of military age, to expel civilians, and to set houses on fire, and this order was approved at that meeting of the political leadership, the appeal chamber considered that a reasonable trial of fact could have concluded that Kordić's involvement in the persecutory campaign was not limited to certain areas of Lašva Valley, in particular Ahmići. Instead, it included in general the then following crimes, inter alia the crimes which occurred in Kiseljak municipality in June 1993. In relation to the crime of unlawful imprisonment of civilians in Travnik, the Dubrovica Elementary School, the SDK building, the Vitez Cinema, the village of Rotili, the Kiseljak barracks and the Kiseljak municipal buildings, the appeal chamber considered that the trial chamber did not err in inferring that Kordić bears responsible for the ordering of the establishment of these detention facilities and the detention itself. Kordić submits that the trial chamber committed an error of fact, occasioning a miscarriage of justice, when it concluded that he had the requisite mens rea for any of the crimes of persecution with which he was charged. The appeals chamber agrees with the trial chamber's findings that Kordić knew that there were attacks on the civilian population which were widespread and systematic, and that these acts comprised part of these attacks. I will now turn to the specific intent to discriminate on political, racial, or religious grounds, and I want to stress first that such a specific intent in general can only be inferred from objective facts and the general conduct of an accused seen in its entirety. Only on rare occasions it will be possible to establish such an intent on documents or intercepts laying down a perpetrator's own mens rea. Here, the circumstantial evidence is clear. At a meeting on 27 December 1991 in Zagreb, Kordić said that the Croatian people of the Travnik area were ready to accede to the Croatian state, and I quote, "at all costs. Any other option would be considered treason, save the clear demarcation of Croatian soul in the territory of Herceg-Bosna." End of quote. Further, at a January 1992 rally in Busovača, Kordić was to be seen speaking to a cheering, flag-waving crowd, and he said that the rally was proof that the Croatian people in Busovača are part of the united Croatian nation, and that the Croatian community of Herceg-Bosna, including Busovača, is, I quote again, Croatian land, and that is how it will be. End of quote. The appeal chamber considers that, inter alia, on the basis of the evidence outlined above concerning Kordić's political activities and inclinations, his strong nationalist and ethnic stance, and his desire to attain the sovereign Croatian state within the territory of Bosnia and Herzegovina at any cost, Kordić possessed the specific intent to discriminate, which is required for the crime of persecutions. On the basis of the foregoing, the appeal chamber affirms the conviction under count 1, persecution, a crimes against humanity in relation to Kordić. In relation to Kordić's fourth ground of appeal, dealing with his criminal responsibility, the appeal chamber considers that the trial chamber's finding that Kordić intended the crimes associated with the attack in Novi Travnik as early as in October 1992 was a finding no reasonable trial of fact could have made. The appeal chamber therefore reverses the trial chamber's finding that Kordić was guilty for wanton destruction not justified by military necessity and plunder in Novi Travnik in October 1992. With respect to the crimes committed in Busovača in January 1993, the appeal chamber, however, has found that a reasonable trial of fact could have concluded that numerous civilians were targeted and killed in the town and that murder, a crime against humanity as well as a crime of unlawful attacks on civilian objects, were committed in this town in January 1993. The appeal chamber refers further to the trial chamber's findings as to the role of Kordić in the campaign of persecution, including his role in the HVO takeover of municipalities, including Busovača, and his role in the events leading to the conflict and on the eve of the conflict. The attack on Busovača was directed against Muslim civilians and civilian objects and aimed at the civilian population. Muslim civilians were killed, expelled, and their property destroyed. It was the trial chamber's finding that Kordić, as a political leader with substantial military influence, was involved in the planning and ordering of these crimes. The appeal chamber concludes that the trial chamber's finding that Kordić had an requisite mens rea for these crimes is reasonable. With respect to the crimes committed between April and June 1993 in the Lašva Valley, the appeal chamber considers that following the meeting of politicians at which Kordić was present on 15 April 1993, a general plan existed to expel the Muslim civilians and to destroy civilian houses. Kordić participated as a senior regional politician in the planning of the military operation and attack against Ahmići, an operation which was aimed at cleansing these areas of Muslims.